Commissioner Fourie.
Thank you, Chief Justice. Good morning, Judge Mbenenge.
Morning, Commissioner.
The Judge President of the Eastern Cape will become the leader of 4 courts
Yes.
in that province. Now, in my view, those 4 courts operate quite separately and or independently. For example, this is borne out by the fact that when vacancies are advertised, it's advertised for Mthatha, it's advertised for Bishu, it's advertised for Grahamstown, it's advertised for Port Elizabeth. Whereas in the Gauteng court, for example, we don't advertise for Johannesburg and Pretoria.
Yes.
We advertise for the Gauteng division. In KZN, vacancies are not advertised as in Pietermaritzburg or in Durban, but the KwaZulu-Natal division. Now, I've had the opportunity during July to travel the Eastern Cape, and I again passed Mthatha, Bishu, Grahamstown, etc. And I just yet again came under the impression that the reason for that might be the location of those 4 courts,
Yes.
and in particular the distances between those courts.
Yes.
Now, I'm a firm believer that if you are a judge president of a division, that you should have a hands-on approach.
Yes.
You should be there, you should be present.
Yes.
And the problems start when judges president are not hands-on and there and are absent. You become the captain of the team, and you got to be on the field with the team.
Sure.
You got to lead the field, the team on the field, and it's no good sitting on the sidelines or in the pavilion starting to direct proceedings on the field when things get tough and hot.
Yes.
Now, if you are to become the Judge President of the Eastern Cape, and it's no secret that there are concerns about the Eastern Cape and the functioning of the courts there. If you are to be the Judge President, and if you ascribe to what I say, that you need to be hands-on to be an effective Judge President, how, and I didn't quite hear that when you spelled out your vision,
Yes.
how do you intend dealing with this problem of 4 courts and your hands-on presence
Thank
in
you.
those courts?
My simple answer, Commissioner, is that the Judge President is responsible for drawing the roster. What I have in mind is that I should be present at least per term, 1 week in each one of those divisions. Be it that I will be discharging appeal functions or duty or post-motion court or purely administrative functions. I believe that I can only be hands-on, not by remote control, but I would have to be in Mthatha for something like a week. I would have to be in Bishop for something like a week. I would have to be in Port Elizabeth for something like a week. Not necessarily as a bystander or a spectator, but there's something that I should be seen to be doing. We must also remember that 2 of those sister courts or divisions have got DJPs. There is a measure of respect and approaching things such that you don't invade the space of a DJP that you trust. And I think what is important is the interaction between the JP and the DJP, and for them to rhyme the same and to have the same rhythm in doing things. In my view, Commissioner, much as you would have to be there and be present and be hands-on, we should always remember that there is a DJP that the JP must trust, that the JP must interact with. That is my answer.
Judge, I'm encouraged by the fact that you said you think you need to spend time at each of those courts.
Yes.
I appreciate the role of the DJP, and I'm not underplaying or underestimating that, but the DJP is not the JP.
True.
And the JP is the captain.
Yes.
The DJP is the vice captain.
Yes.
But I am encouraged to hear that, and I think you're quite right that you need to physically spend time
Yes.
at each of those courts
Yes.
in order to have a hands-on approach.
Yes.
Perhaps on a lighter note, during the last time that we interviewed you was in October of 2015 for the position of DJP.
Yes.
On that occasion, Commissioner Malema said to you, you can't be baptized today
Yes.
and appointed the pastor the next Sunday.
Yes.
What you're telling us today, suggesting that you are of the view that it is now time for you to become a pastor.
Yes. Yes. In a manner of speaking, yes. He spoke about baptism and the fact that you can't really wake up the following day and say, where do the pastors sit? I'll never forget that day. Anyway, let's call it, let's put it like this. I did sum it up and I said, when I was here, there were people who believed that I could lead. The same people have nominated me, being of the view that I can lead. But this time around, let me face Commissioner Malema. Let me look at this side. This time around, I have been afforded the opportunity to prove myself. Where are the chairs? Where do pastors sit? I can pose that question.
Thank you. Thank you, Judge. Thank you, Chief Justice.
Thank you, Commissioner Fari. Commissioner Nokesi.
Thank you, Chief Justice. Judge Mbenenge, out of your plan that you have outlined, there were two things that I would like to raise with you. I think the Chief Justice would like as well to hear you speak on these matters. There is a challenge of the delay of delivery of judgments.
Yes.
That I'm speaking from my background as a practitioner. It's subject to lawyers to some difficult situation. When a client comes to ask about his judgment, you say, no, the judge said it's reserved, that week is reserved. You end up hiding yourself under the desks simply because the judge has reserved a judgment. Firstly, during your acting stint in Mthatha, did you observe that challenge? If yes, what is your plan of action in responding to the issue of the delay of delivery for judgments?
Thank you, Commissioner. It's not just about what I plan to do in future. I can share what I have done, and I believe the AJP will bear me out here. The starting point is that norms and standards stipulate that, if at all possible, you should be able to say to litigants and practitioners, I am reserving judgment, and I will be handing it down on such and such a date. That is the starting point. Judges do this when it comes to criminal cases. They reserve judgment on the merits, and they indicate when judgment will be handed down. And I don't see why there should be a difference when it comes to civil cases. But let's accept that at times civil matters involve complex issues of law. The norms and standards make it clear that judgment must, as far as possible, be handed down within 3 months. And what I have done, what I will continue doing if afforded the opportunity, or even if not afforded the opportunity, what I will influence in this division is this, that come end of the term, you circulate a form where judges commit themselves, pointing out what judgments were reserved, what dates they were reserved on. For starters, this is done at the end of the term. We all know from a reading of norms and standards that recess is not vacation. Recess is time to work on outstanding judgments, partly heard matters, and so on and so forth. That's very clear. The reason why I do it in that fashion is that when we reopen, when there's reopening or when recess is over, I circulate the same form. That form is going to tell me what judgments were written over recess. But the second time around, there'll be a column if a judgment has not been written to a finish, which says anticipated date of handing down of judgment. So that system, in my view, is a system that I would sell for the entire division. And let me mention that for the second term, I did circulate the same form. I did that when I had been acting for that particular term, May to June. And I forwarded that form to the AJP for him to get an idea of who has not handed down judgment and so on and so forth. I did the same at the end of the term that ended in September. And I wrote a note to the AJP to the effect that it may be that we will have to deal with the issue of long outstanding judgments. I'm happy to announce that there's only one outstanding judgment from the form that I gleaned from the form that I circulated and which attracted responses from the judges. There's one outstanding judgment, and regrettably, it's been outstanding for something like 9 months, and it's something that I've spoken to the AJP about. I've spoken to the judge concerned about in soft tones, President Maya. Question being, when is the judgment likely to be handed down? It's not a nice question, eh? It's not good. But
Wait a minute, in which division?
Mthatha.
Well, I'm surprised because I was actually sending the Mr. Chilwane around saying I've got the report on reserve judgment.
Yes.
From Grahamstown, Bishop, and Port Elizabeth.
Yes.
Where is the report on Tata? And it says they say there is no reserve judgment.
Well,
there's nothing at all.
I do have the relevant form that I forwarded to the AJP. Remember, I must observe protocol.
No, sure. I'm just expressing. I'm
yes,
not condemning you.
Yes.
I'm just expressing surprise because when judgment has been reserved for 3 months at most,
yes,
it must reflect in this report. And,
I hear you,
and it's
CJ.
not even there. And it worries me when it comes to the Eastern Cape because I learned at some stage for the first time during the interviews that there's a judgment which was reserved for some 6 or 8 years.
Wow.
And that's why I'm very particular about the Eastern Cape as well.
Yes, the concern is legitimate. CJ, I have mentioned to the Commission my plan that I've implemented. I know it may attract a measure of wrath from those affected, but the norms and standards are there. They tell us what should happen. But in this particular instance I was mentioning, I interacted with the judge concerned, and the answer that I got was simply that it involves complex issues of quantum in a medical negligence case, and the judge concerned informed me that there was interaction between the two of them, that is including the judge concerned and the AJP, that something will be done. But fortunately, I have been informed by the judge concerned that the judgment will in all probability be handed down on 17 October. I'm just missing let me just check. I've got the correspondence here. But there is an indication that the judgment concerned will be handed down. It's the matter of Mamposa versus MEC for Health, a matter with complex issues when it comes to medical negligence. It was reserved on 2 December 2016, and the anticipated date of hand down, based on the form that I circulated, giving effect to my plan of action, it will be handed down on 17 October 2017. It's a matter that I have discussed with the AJP. So there is that plan which I have implemented, which I will continue to implement, even if it attracts a little bit of discomfort from colleagues. You have to suffer for beauty.
Thank you, Judge. I'm taking comfort that you have some plan on the issue of quick delivery of judgments. Now, there is also another concern which we have, particularly from the NEEC, a committee in which I sit, the overcrowding of prison cells, particularly by persons who are, I mean, you have somebody who's granted bail, 500 bail, we cannot afford it, but is kept there. Or somebody who should not even in the first place should have been
sentenced.
Should have, I mean, they are awaiting trial prisoners. He should not have been locked. All what you should have done, given notice to the person to appear in court.
Yes.
Do you have any plan in responding to the issue of crowding of prison cells?
Yes.
I mean, these are the issues that I believe in the PECC you must have dealt with, or I mean, you must have interacted with these matters.
Yes.
What do you have any plan around that?
Commissioner Notiesi, overcrowding does not come about purely because people have been refused bail or have been granted bail which they cannot afford to pay, but it also crops up in instances where magistrates send people to prison because they avoid the review processes. They don't want to be queried. In relation to that, all I can say is that meetings involving the judge president and or the deputy judge president, together with officials from the Correctional Services Department and from particular magistrates' courts, would have to sit and they would have to converge and discuss these issues on a daily basis and conscientize one another in relation thereto. The only solution is, firstly, conscientizing people about the problem, identifying the relevant people, and I've mentioned the relevant functionaries, and a cure to the problem will come about easily if that approach is adopted.
Chief Justice, I'm sure it will be my third question, which is the last. On the issue you outline on the role, I mean the running role, civil role, and all that, case flow management also in application or in motion proceedings, because it seems as if the understanding is that this case flow must only be on trials.
Yes.
Now, my question, particularly with regard to the Eastern Cape and in Umtata, where urgent applications are simple denied of their urgency by judge. Once there is a notice to oppose, it just pushes back and then it's just become an ordinary application. What is your view on the establishment of an urgent court motion that is running parallel to the motion court?
Yes. Earlier on, I alluded to decentralization of functions from two judges who are called duty judges during a particular week, a situation which, in my view, is not appropriate tapping of resources. I mentioned that it should be possible for one judge to entertain unopposed applications. And in those courts where unopposed applications exceed 60, 70, or 100 for that matter, you can then have two courts, one court running on Tuesday and another on Thursday, presided over by the one judge. But over and above that, that judge should hear urgent matters. Urgent matters should belong to that judge, because invariably that judge may complete the role on a particular day by 11:30 or 12 noon, and we'll have to deal with certificates of urgency and urgent opposed matters. So the dispensation that I alluded to earlier on should, in my view, take care of the concern that you've expressed.
Last question now. This is the last question. This relates now to you personally. there is a perception, or there are some. I mean, if you can comment to this question, because I don't have anything written with me, so you can simply, you don't want to, that you are sort of an aloof person, and that you among the practitioners, you do prefer a lot of senior counsels more than the attorneys. What is your response on to those matters?
Yeah, the concern, it's not even a complaint, it's very illegitimate. I'll tell you why I say that. At a time when I was chairperson of the bar, I'm going to mention no less than 3 attorneys who were appointed to become judges because of my influence. I'm going to mention them. AJP Ndlangulela, Justice Spetze, who is now serving in the SCA. Who else? I'm not certain in the case of the late Tugada, who was also an attorney. You'll remember earlier on I alluded to my vision about acting appointments. I did not confine it to advocates or senior counsel for that matter. The fact that I was senior counsel at some point would not justify me preferring advocates and senior counsel over other practitioners from other branches. I presented a broad picture. Even an attorney can outdo an advocate. I've seen this happen, Mr. Commissioner Nokyesi. I've seen attorneys appearing against advocates and articulating their points in a more structured fashion than what advocates have done. So there is no basis whatsoever for this perception which you've shared with the Commission. I interacted with attorneys. I have encouraged attorneys to consider at times, moving from the conventional school of thought, some to go for advocacy and others to become judges. In fact, at the time when Justice Spetze was considering, at that particular time, Justice Spetze was considering doing pupillage under me, and I said, hang on. Now, Chief Justice, let me quote yet another story. Who am I to baptize you? You must baptize me. You remember that story? I said, you are bench material. I encouraged him to go to the bench, and he did well. He still does, I believe. So, is there mention of me being aloof? I wonder what the basis of that is, because I interact with people freely. I'm never aloof. And there are many people here that I've interacted with. They will bear me out. There is an element of being a social giant on my part. And people will bear me out, those I've interacted with. Thank you.
Thank you, Commissioner Nokyesi.